We had a big day in court in the Bryan Kohberger case on Friday, August the 18th. There were a number of motions that were scheduled and heard before the court. I was there for the whole thing, so I'm going to tell you about what I saw. As has been the case for every hearing since the arraignment, this one was pretty sparsely attended. It doesn't really surprise me because these are fairly technical legal issues, and as we're going to get into, the media seems to have a little bit of trouble with reporting that kind of content. But by and large, it was more or less the same folks that I'm kind of becoming accustomed to seeing at these hearings, mostly local news reporters, some national. There was a lady from CNN. Obviously, Court TV was there. They're running one of the pool cameras. The exception to this was that quite a few members, 6 members of the Gonsalves family were present, along with Shannon Gray. Shannon Gray was indeed wearing his boat shoes again, guys. I know some of you guys want those really critical, hard-hitting details, so there you have it. But in another sartorial observation, you may have seen, I think it was Court TV that caught an image of one of the Gonsalves family members was wearing a T-shirt that raised my eyebrows a little bit, maybe less significant in the context of a hearing like this than it certainly would be at trial, but nevertheless, probably pretty inappropriate for the courtroom. What it said is it had a hashtag justice for Kaylee, and then a picture of, image, a graphic of the scales of justice. Idaho HB 186, which is the House bill that put the firing squad into place as a potential mechanism of execution in death penalty cases. And then it said shots fired. I will say that it's not large. It's small font. I think it's entirely possible that the judge looking from the bench would not have been able to read it. In fact, I think it's also entirely possible that defense attorneys sitting at defense counsel table, if they were looking over in that direction, they may not have been able to read it either. I was literally sitting 2 rows behind this person and had to kind of squint, real hard to try to see. And no age jokes. Okay, my eyes are great. I'm not that old. I still have my perfect vision, no contact glasses, nothing like that. So good try. But no, it was very difficult to read. So it wasn't super in your face. I kind of suspect that might be a reason why it wasn't addressed. It could be that the court was just letting it slide for this hearing. But I can say that, if something like that were to show up in the context of the jury trial, that almost certainly would not be allowed to be worn into the courtroom. It's common that they will make you take your shirt off and turn it inside out with those types of messages on it. So that was certainly something that I noticed there in the room, part of the overall environment. Another thing that we saw coming into the courtroom is that there was a sign on the door announcing that one of the attorneys had recently tested positive for COVID, and that under current CDC guidelines, it was okay for that person to be at work with precautions. So we can probably read through the lines about what that means, given who was masked in the courtroom and who was not. But the court did provide all kinds of masks, hand sanitizer, things like that were available for anybody in the courtroom. I have to say I'm not real familiar with the current CDC guidelines. I haven't really paid attention to that, so I don't really know what's going on with that. But that's something that you wouldn't have known if you were not there, that apparently somebody on one of the legal teams has been dealing with COVID in recent days. I'm just going to give a brief overview of what was before the court, kind of what happened, what the decisions the court was being asked to make were, and not go too much into the details about what actually happened, what witnesses said and things like that. I'm going to save that for a future video. But for now, the thing to know is that there were a number of motions before the court. So here is what the court was there to consider. From the state, they had the motion for the protective order. This dealt with the investigative genealogy information, the details about that investigation, the work product that was produced as part of that investigation. A motion to reconsider the order staying speedy trial. This relates back to when Ann Taylor had requested a stay in order to basically review the grand jury materials that have to be provided to the defense and evaluate whether there are potential challenges that would undermine the indictment or the grand jury proceeding. Judge had originally granted that and imposed a stay of 37 days, the practical effect of which was to extend the speedy trial deadline from sometime in, I think it's currently either in late October or early November. It would have extended that basically another month. It's kind of moot because as of now, the trial is set for October 2nd. We're going to get into that a little bit more too. But so the state had asked the judge to reconsider that decision to add another additional 37 days to the end of the speedy trial period. The state brought a motion to compel the defense to comply with the alibi statute, to provide formal notice, as the statute says they have to do if they're going to pursue an alibi defense, naming the witnesses, providing their contact information, and identifying the locations where Mr. Kohberger claims that he was during the events in question. And then lastly, the state had also asked for a scheduling order. On the defense side, we had kind of the counterpoint to the motion for the protective order. The defense had moved to compel not just the production of the investigative genetic genealogy information, but also there were some other details dealing with some of the other testing and processes, specifically asking for emails from the lab that the defense had reason to believe existed because the emails they had received referenced other emails and attachments, which they did not. And then also details about the DNA of 3 unidentified male subjects who the DNA was found, 2 of them in the home, in the crime scene at 1122 King Road, and 1 of them on a glove outside. And so the defense was seeking basically information about how those samples had been handled, processed, had they been submitted to CODIS. Now, CODIS is, as you may know, the federal combined DNA index. There's lots of different ways that DNA gets put into that database, but it's basically a central depository that is used a lot for investigative purposes to check a sample you have to see if it matches up with somebody in the database whose identity is known. And then lastly, an additional motion to stay speedy trial regarding some further grand jury irregularities that the defense was alleging. Now, something that did not go forward today that is important to mention because of something that happened later on in the hearing was the motion that the defense had brought to dismiss the grand jury indictment on the grounds of irregularity. The parties had agreed beforehand that this was going to be kicked out. I don't believe we only just recently saw a response from the state on this. And so Judge announced at the very beginning of the hearing that that particular motion was not going to be heard today. They were going to defer it to a later date. Notwithstanding that, apparently what happened is somebody in the news media got a hold of the state's response brief. In the state's response brief, they had attached copies of decisions from other jurisdictions dealing with similar motions to dismiss a grand jury indictment. And the very last one was a decision from Canyon County signed by a certain Judge Petty. So at about 3 or 4 o'clock in the afternoon, after one of the recesses, Judge came onto the bench and advised the media that perhaps they might want to be a little bit more careful in the facts that they were reporting, in making sure that they understood the documentation that they were communicating to their readers, because somebody had apparently gotten a hold of the state's response and then went out and reported that Judge Petty had denied Bryan Kohberger's motion, which of course did not happen. Judge Petty is not on the case, and Judge has not heard the motion. So Situation clearly where somebody did not understand what they were reading and jumped the gun in a hurry to get the scoop, which is kind of an unfortunate pattern that we continue to see with the media reporting on these types of cases. So somebody jumped the gun, had wrong information, put it out there, it took off, and so probably there are now people out there who think that motion has already been dismissed. Maybe it doesn't matter. I don't know. Maybe it does. But it just doesn't really bode well for the behavior of the media in this case that continues to be an ongoing issue. Speaking of the behavior of the media, there was a little bit of a kerfluffle with the pool cameras. Guys, I don't know what it is. I don't know why these pool cameras can't just follow the judge's order. So from my position where I was sitting in the courtroom, I was sitting behind the prosecutor's table, about 3 rows back. It's basically the prosecutor's table, the bar, and then 2 rows that were the Consalvis family was in those 2 rows. And then myself and my friend Heidi, who came to sketch, we were sitting in that 3rd row. That gives Heidi the best perspective to be able to see like judge's face and stuff like that. So that's where we like to be. So anyway, we're also on the same side as the pool cameras. We're just a couple rows behind them. And at least one of the cameras has a big, playback screen that just is there. And so we can watch and see what they're recording. And so we see for the entire day, this camera is doing exactly what Judge has said they cannot do, which is zooming over to Bryan Kohberger and getting way in tight on his face while he's just listening to witnesses testifying, try to catch, some reaction or something like that. Just very, very fixated on Bryan and not on the proceedings that are happening in the court. So they had been specifically admonished by Judge in the past that they're not supposed to do that. There was some kind of interaction between the bailiff and one of the camera people. Didn't, get all of the details, so I don't, really want to guess about what was happening there. But it did seem clear that they were talking about those restrictions from the judge. There was a comment about, you can focus on the judge. The cameraman kind of shoots back a little snarky, well, can I focus on you, to the bailiff? And so I don't know what came of all that, but just appears to be a continuing pattern that the media is not going to comply with judge's restrictions. And this is really jeopardizing the potential for those cameras to stay in the courtroom, guys. I don't know what it's going to take to get them to just follow basic rules. I don't know why they think they are above this procedure and this process. But it's a problem. So haven't heard anything yet. Don't know if there's going to be motions. Don't know if there's going to be, any type of request that the cameras be removed from the courtroom. We do know from the past that the defense doesn't really want them there. They've asked for them to be excluded. Wouldn't surprise me if that request is renewed. They have a consistent pattern now of the media disregarding it. So we'll see what, if anything, comes of all of that. And I certainly don't want to give anybody any trepidation about, what to maybe expect as trial is coming up. But yeah, I got to tell you, it's not really looking good for the prospect of this one being televised. So the quick and dirty rundown of what the decisions were in the case. First off, on the investigative genetic genealogy stuff, no decision. That has been taken under advisement. The state is also going to potentially have the opportunity to either recall the defense witnesses to cross-examine them or potentially put on their own experts to rebut that defense testimony. We'll probably find out more about that at a later point. So no resolution of the motion for the protective order, and by the same token, the defense motion to compel with respect to the IGG. The judge did, for all intents and purposes, grant the order for reconsideration, staying the speedy trial, extending the speedy trial deadline, and denied Ann Taylor's, the defense motion to basically have an additional stay for grand jury irregularity investigation. Basically, the basis for that was that the irregularities that the defense had identified were not substantial. They were just the kinds of things that ordinarily happen. Mistakes happen. People forget to check boxes and stuff like that. So nothing that was really significant in Judge's opinion. So what that practically means is that 37 days that he added on to the speedy trial deadline, he now just went ahead and took it back. For reasons we're going to talk to in just a second, that's not likely to be very significant. The motion to compel the notice of the alibi was, for all intents and purposes, granted. He basically required Ann Taylor to present alibi witnesses by a specific date. And so to the extent she has them, he did express some skepticism that, you know, the position the defense has is actually an alibi defense, which I think is understandable. It's not really an alibi. He's not saying I was in another specific place. He's just saying I wasn't there. Don't know exactly where I was at any given point in time. So don't know exactly how that's going to flesh out either, but basically, if there is anything more substantial that the defense has in terms of identifying his location at the times of these murders, they're going to be expected to produce that to the state within about a couple of weeks. The last thing that the judge did is grant the motion for a scheduling order and gave us a whole bunch of deadlines because, guys, October 2nd is 6 weeks away. I mean, they have a ton of stuff to do in a very short period of time if this thing is going to go forward as it's currently scheduled. So I'm going to go through the deadlines he gave. First off, discovery. Discovery for trial for the guilt phase. The cutoff is going to be September the 1st. Basically what that means is that if it hasn't been produced by that date, chances are pretty good it's not going to be admissible at trial. The judge set a slightly longer deadline for disclosure of experts for mitigation and sentencing, should there be a mitigation and sentencing phase in the case. These are often things dealing with like psychological information, developmental experts, things like that. So to the extent that those are going to be presented, those need to be disclosed by September the 15th. For experts, otherwise, for the fact portion of the trial, those disclosures, the cutoff is September the 8th. And then rebuttal experts in response to those have to be disclosed by September the 15th. The alibi evidence, if any, has to be disclosed by September the 8th. Pretrial motions that have to be filed by rule, including motions in limine, motions pertaining to the death penalty, motions to suppress, etc., have to be filed by September the 8th. So soon. I do not envy these guys at all. The responses to the motion have to be filed by September the 15th. Proposed jury questionnaires have to be filed by September the 15th. Proposed witnesses all have to be disclosed by September the 8th. Rule 404B notices. This is notice to the other party if you intend to present evidence of somebody else's misconduct, somebody else's, what they call prior bad acts. And essentially what this is if there is something outside of the universe of facts for this trial, like what happened in this case, that the parties think have some bearing on determining guilt or innocence, for some reason other than just it makes this person look like a bad person, therefore they probably, did this bad thing or whatever. This often comes up with things like wanting to prove motive, wanting to prove a pattern of behavior, things like that, because you're dealing with stuff that isn't necessarily directly pertinent to the crime, but you're arguing that it's relevant for some other type of purpose. So those notices have to be in by September the 15th. All of the motions are going to be heard on September the 22nd at 10 a.m. Judge set aside the entire day. Yes, it's on my calendar. Jury selection, the first steps to qualify a death penalty qualified jury is going to start on September the 25th. Final pretrial conference is going to be held on September the 29th. Trial is going to be held on October the 2nd through November the 17th. The only other thing that's going on in the interim is that motion to dismiss the grand jury indictment, which we mentioned did not get heard on Friday the 18th, got continued out, and the judge set that for hearing on September the 1st at 1 o'clock. So that's what we got coming up in the coming 6 weeks. It's a lot of stuff. Before the court ended, Ann Taylor also asked the judge to set a status conference, a brief status conference for Wednesday, August the 23rd. They're going to hold it at about 2:15 in the afternoon. Not clear what exactly the status is for. My suspicion is that it probably has to do with kind of following up on this hearing that was held today. It likely has to do with following up on the hearing that was held on Friday, because there were some loose ends resulting from that. Whether or not the state is going to call any additional witnesses, whether or not the state wants the defense witnesses to come back to be cross-examined, those types of questions are going to need to be answered, for the defense to be able to kind of move forward and understand what their options are and what their position is as they decide whether this schedule is what we're gonna do, whether we're gonna stick with this October the 2nd trial date. And the reason why is because Judge also gave Bryan Kohberger a deadline to waive his speedy trial. And that deadline is September the 8th. So that's our outside date for knowing whether this thing is going to go forward on October the 2nd or whether it's not. If he waives, then it's likely going to get continued out to get them more time. If he does not waive, then we are going forward on October the 2nd, less than a year from the murders themselves. It's an extremely accelerated period from my perspective, especially from a death penalty case. And so I certainly have some thoughts on why they might want to do that, but I'm going to save them for a future video for you guys. So that's the basic overview of the roughly 5.5 hours that we spent in court on the 18th, dealing with all these motions. I am going to come back and get into a little bit more detail about some of what happened here. Guys, part of why I've been a little quiet here lately is just because the way I've been sort of conventionally making videos is very production heavy. It does take a lot of time and effort, which I just have not had a lot of this summer. And I will admit I have prioritized kind of enjoying my summer a little bit, taking advantage of, beautiful outside and weather and so forth. So I am trying to find ways to kind of make that a little bit more efficient so I can get some more stuff out, maybe cut back a little bit on some of the production that I do, put out some more kind of quick take, quick reaction types of things, just so you can get my perspective on what's happening without necessarily having to wait for me to read the entire textbook and summarize it for you and stuff. It's just my type A coming through, but we're trying to work with that. So anyway, that is my goal, is to be able to hopefully give you guys more content, maybe a little bit shorter, maybe not so flashy, but to give you guys the meat that I know that you're looking for with this type of analysis. So I will also say my calendar on August the 23rd is free, that status conference. So I'm going to kind of just keep an eye on my workload and see what I can do. But so far, I'm going to cross my fingers, try to be there for that one as well. So I will keep you posted if anything changes. But in the meantime, thank you very much for sticking around to watch this. I will look forward to seeing you in the next one.